or any other statute imposing a requirement to hold a public meeting or hearing, the City of Johnston will conduct meetings electronically with the public allowed to attend per instructions denoted on the meeting's particular agenda. Meeting minutes will continue to be posted per the city's normal course of business. We have called the meeting to order. Cindy, roll call, please.
Councilmember Cope.
Here.
Evans. Evans.
Where'd he go?
He's there. We'll come back. Councilmember Martin.
Here.
Ready?
Yep.
Soroka.
Here.
Evans.
Here. Here.
Thank you.
With that, we will move into the hearing proceedings itself. And as I indicated, we are here this evening in a hearing to hear an appeal regarding an appeal filed on behalf of Dr. Rachel Sokol to the Johnston City Council. The appeal stems from an incident on July 20, 2020, in which an Amazon driver, Heather Isaac, was delivering a package to the Sokol residence at 7040 Northwest Beaver Drive when she was allegedly attacked by the two Sokol dogs, Tess and Marley. It was alleged that the driver sustained serious injuries and a broken arm as a result of the attack by the dogs. The Johnston Police Department then conducted an investigation of the incident, and on July 29, 2020, Chief Dennis McDaniel found that both dogs would be declared dangerous dogs under the Johnston City Ordinance, Chapter 55. On July 29, 2020, Attorney Bill Mallory filed a notice contesting Chief McDaniel's decision and appealed the decision pursuant to the Johnston City Ordinance, Section 55.10, to the Johnston City Administrator, Jim Sanders. On August 17, 2020, the appeal hearing was held before Jim Sanders. Subsequent to the hearing, Jim Sanders, on August 24, 2020, issued an opinion upholding Chief McDaniel's finding that the two Sokol dogs are dangerous per Johnston City Code. On August 24, 2020, Dr. Sokol, through her attorney, Mr. Mallory, filed a notice appealing Jim Sanders' decision, and that brings us here tonight for this appeal hearing. Present for this hearing this evening are myself and council members, and why don't you wave when I call your name? Tom Cope, Jim Evans, Rhonda Martin, Suresh Reddy, and Scott Soroka. City Attorneys Tim Pearson and Rob Layton. Attorney, and I guess sitting in for Bill Mallory, is Dan Kresowick. I hope I got that right.
Yes, that's correct. Thank you.
Is Dr. Rachel Sokol with us this evening, Dan?
She is not, Madam Mayor.
Okay. Chief Dennis McDaniel is on with us. How about Lieutenant Stephen Norrie? Is he on? Doesn't appear that he is on. How about Officer Taylor Parrish? Yep. Doesn't sound like she's on. City Prosecutor Larry Handley?
Mayor, just to clarify the record, Lieutenant Norrie and CSO Parrish are here in the room.
Okay. And Larry Handley as well?
Yes.
Okay, very good. Also in the room with me is City Administrator Jim Sanders, and as I indicated earlier, Attorney Tim Pearson. Is there anyone else that is present that I have not yet identified? Okay. Cindy, is there anyone else that has dialed in as a member of the public this evening?
No, there's not.
Okay.
Mayor, I'm on the call as well.
Yes.
Okay, Teresa Rocheffer, our budget director, is on as well. This hearing will be based upon the record made before the city administrator, the arguments of the parties or their representatives, any additional evidence which was not available at the time of the appeal hearing before the city administrator, and any other information the council deems necessary. Prior to this evening's hearing, the city submitted information related to the record made at the appeal hearing before the city administrator, as well as additional evidence that was not available at the time of the hearing and/or that would be necessary. This information, and bear with me, includes the official record case 20-001025, case 20-000769, A, incident report and supplements, B, video of incident, C, victim photos, D, code section 55.11, exception to declaring a dangerous or potentially dangerous dog, case 20-001025, E, incident report and supplements, F, photos of offending canines, G, photos of injuries, H, declaration letter, I, victim statement, handwritten and translation, J, map with victim's path, K, audio recording of victim interview with Detective Schrage, L, JGMFD report, M, Unity Point records, N, Vivint security footage for day of incident, O, Jim Sanders notes from appeal, P, appeal decision from Jim Sanders, Q, 1979 Iowa Attorney General opinion 17.6, 716.7, R, code section 55.01, definitions, S, code section 55.10, declaration, impoundment, and appeal of a dangerous or potentially dangerous dog, T, code section 55.13, keeping of a dangerous dog, and U, code section 55.14, insurance coverage requirements. And then going to the additional information. The additional necessary information for case 20-000769, 1, the medical records. For case 20-001025, item 2, zip file of body cam video from Officer Kerr, Trio, and Abel responding to the scene, and CSO Parrish delivering dangerous declaration letter. 3, Amazon Logistics shipment detail. 4, Vivint preservation letter. 5, search warrant return with supporting information, Vivint security. 6, email from Colin Grace with ARL impound agreement. 7, photos of keep out signs on property. 8, summary of phone calls between Rachel Sokol and CSO Parrish. And 9, audio recording of phone calls between Rachel Sokol and CSO Parrish. And I have been advised with respect to the additional necessary information that since it was not previously entered into the record, that we should take a motion from the council tonight to accept that information into the record if you find that it is necessary. So I would entertain a motion to accept the additional necessary information.
And Madam Mayor, before you get to that, I don't know if this is appropriate time to object to that information or request a continuance. I believe Attorney Mallory spoke with Attorney Pearson or corresponded with him earlier today or possibly yesterday about us making a motion to continue this hearing.
Well, let me take a motion first on the additional information. Since we've teed that one up, is there a member of the council that would make the motion to deem the additional information necessary?
So
I
moved,
move.
Evans.
I move second.
Motion from Evans, second from Reddy. Cindy, vote please.
Councilmember Evans,
Yes.
Martin,
Yes.
Reddy,
Yes.
Soroka,
Yes.
Pope.
Yes.
Now, Mr. Kresowik, on your, why don't you restate your request?
Sure, certainly. Madam Mayor, council members, my name is Dan Kresowik. I represent Ms. Sokol along with my co-counsel Billy Mallory, who is not able to be here today. We formally request that the council continue this hearing primarily for the reason that we received those documents, and when I say we, I mean my co-counsel, Billy Mallory, received those documents on September 10th. He was out of the country until 9 p.m. this past Sunday, so less than 2 days ago. So he had one business day to go through those. That's why I'm here. He brought me on. He wasn't going to be able to address everything. We made some phone calls, and we have been unable to secure the presence of two what we would consider necessary witnesses. One, a neighbor of Miss Sokol's who didn't observe the incident but was present on that day. Two, an Amazon worker who can provide us with their details of what Amazon's procedure is when confronted with a situation where there are dogs present or where there are trespassing signs present. The third reason, Madam Mayor just recited a list of documents that I guess it would be, were provided to my firm on the 10th. Again, we haven't had time to go through all those and find either rebutting documentation or other witnesses necessary to support them. Some of the documents or some of the folders that were included in those documents were also empty. For instance, there's one labeled keep out signs, there was nothing in there. Phone calls, which were apparently audio calls recorded with our client, nothing was in there. So I'm not sure we have all the documentation that Madam Mayor just recited. Thank you.
Well, just so that the council members are aware, we did receive a call from Mr. Mallory earlier today. It was a call to Tim Pearson, indicating that he would like to continue the hearing from this evening. It was unclear as to what the reason was at that time, other than that he said that he might have another witness. The fact is, I've been advised that Mr. Mallory did receive notice of this hearing on August 31st. He did receive the Zoom invite on September 8th. There was a discussion between Attorney Pearson and Mr. Mallory on September 9th regarding the open records request that Mr. Mallory has made, and he was asked at that time if he wanted to continue the hearing, and he said no, that he wanted to proceed with it. So that brings us here today. I'm a little confused as to the statement that Mr. Mallory has not received the documents.
Well, Madam Mayor, I might comment that I did talk to Mr. Mallory on the 9th of September, one day after we received the open records request, to advise him that we had 10 business days to answer some of these requests, and we needed some clarification, but for the ones that we could probably get to, we had 10 business days, and those days went beyond the date of this hearing. And Mr. Mallory unequivocally told me I asked him if he wanted a continuance because we'd have to notify the council, and if that was the case. He unequivocally informed me that he did not want a continuance. As today, I received an email at 8:25 this morning from Mr. Mallory asking for a continuance because he had another witness that he did not believe that would be available for tonight. I had spoke to the mayor and advised him at that point that if he wanted to make a motion to keep the record open, that was his prerogative. But as far as as far as the city was concerned, they wanted to go ahead and proceed with the meeting tonight. We have well over a dozen individuals who have that we had to get together to coordinate this time and place. They all took their time and their effort to be here tonight. And in terms of the information that was supplied, the information is to the record. The first agenda or table of contents that the mayor wrote, Mr. Mallory is fully familiar with that. He was at the hearing that made that record. He has seen every bit of the evidence on that. I would say at least a majority of the evidence on that prior to receiving all the documentation by Dropbox on September 10th. So I'm just stating for the record the facts of what has occurred in terms of this request for continuance and the hearing here tonight. Thank you.
Mr. Creswick, it's difficult to get all of these individuals together at any one time, and that is part of the reason why I indicated earlier today that I would like to proceed with this hearing this evening. I assume you're prepared to move forward with the hearing this evening, given that
If need be, Madam Mayor, can I make one statement? I believe when you were referencing the documents that were provided, I believe you made a comment about that they weren't available prior to what we'll call a prior hearing. I don't believe that's entirely accurate with respect to some of the documentation that's been provided. I think some of the transcripts and videos, to my understanding at least, were available prior to that prior hearing. So I just want to make a point of clarification with respect to when those documents or videos were provided compared with when we received them. And then I'm not sure if Attorney Pearson wanted to address the comment. It's my understanding with our Dropbox, there was nothing in, I've got it on the computer here, there's nothing in the folders labeled the signs or the phone calls that were apparently recorded between our client and perhaps the police department.
Which one?
Mr. Creswick, if I'm understanding you correctly, you're saying that some of the items that are listed on the page that say additional necessary information, some of those documents were previously available? And
yes,
some you still have not received?
Yes, that is correct.
Can
Looking
you
at, yep. If we go into an additional necessary information,
right.
There's body cam footage, which has, I'd say about 9 different items listed. Then there's a folder for keep out signs, which is empty. A photo for phone calls, which is empty. And then 3 loose documents, Amazon delivery documents, Colin Grace ARL agreement, and dangerous dog impound agreement.
I need a tech person here.
We just need to hit the additional, the box should come up. We can go to those boxes.
Boxes here. I'm trying to operate someone else's computer. I apologize.
1025. There you go.
Well, I just opened, Mr. Creswick, I just opened item number 7, the photos of the keep out signs, and ours has, at least the file that I opened has pictures in it.
Do you know who uploaded those to the Dropbox, or? I assume there's a way to check the Dropbox.
Yeah, I just opened the Dropbox on our end, and the pictures are there. Did you refresh your Dropbox, Mr. Presswick?
That's a good question. I've never accessed the Dropbox. I just have what's on our system. And we spoke with, obviously, Attorney Mallory and his paralegal, and they informed me there was nothing in there for the 2 items I mentioned.
And what was the other one while you're looking?
It was, let me see. Additional necessary information. Phone calls, nothing in phone calls. Body cam footage had 9 documents, nothing in phone calls.
Sure. Okay, so I've just opened up, Mr. Kreslik, I've just opened up or had someone open up for me, the phone call file, and there are a number of audio documents in that file.
And you can verify those were all placed in the Dropbox or shared with the Dropbox with our office?
Yes. The person who did it is standing behind me, and she says yes. I mean, it seems to me, Mr. Kreslik, that if we can access those documents in the Dropbox, you know, it's just, as I understand it, it's the same Dropbox that you have.
I would assume so, yeah. I mean, like I said, I've never had the link to the Dropbox, but I don't know any reason that wouldn't be accurate.
For what it's worth, Mayor, I checked and I was able to open the photos on my Dropbox that showed the keep out photos as well, so.
Yeah, I mean, it's the same Dropbox. I mean, we all have access to the same Dropbox, and so if it's available to you and me, it's available to anybody who has access to that Dropbox, as I understand it. So, Mr. Kreslik, if you are prepared to proceed this evening, that is what I think we need to do. We have everybody here. We can certainly entertain a motion at the end if we want to keep the record open and receive any additional information. We're more than willing to do that.
Okay. Would you like me to proceed?
Yes, and just reminded by our attorney that I need to go on record saying that your request for a continuance has been denied.
Okay.
In terms of how we will proceed this evening, Mr. Kreslik, you will speak first, then Mr. Handley will speak, and then Mr. Kreslik, you will have an opportunity for rebuttal. At the end of those presentations, then, those arguments, those presentations, the council members will have an opportunity to ask both of you questions. And we'll see where that takes us. So, Mr. Kreslik, do you want to proceed?
Thank you, Madam Mayor. Madam Mayor, council members, again, my name is Dan Kreslik. I represent Ms. Sokol in this appeal. One of the documents that has been filed or submitted as part of the record is your code section 55.11. As part of that, subsection 4, I'm going to read it briefly. A dog shall not be declared as dangerous or potentially dangerous if it bites, attacks, or menaces a person, domestic pet or animal, if, subsection 2, it is protecting itself, its young, or another animal, or subsection 4, it is defending its owner's or caretaker's property against trespass, or 6, if the threat, injury, or damage was sustained by a person who, at the time, was committing a willful trespass. Iowa Code section 716.7, subsection 2A, also defines trespass, and I believe that's referenced in the 1979 Iowa Attorney General opinion, which was submitted as part of the record. It is our position that, and I'll refer to her as, just for sake not to have argument, as the victim. I know we're saying alleged victim, but I'll just call her the victim so everyone's clear, that she was trespassing at the time of this incident. It's our understanding that she was an Amazon delivery person. There's a incident report from officer, and I'll spell it A-B-E-L-L, Sam Abel. I apologize if I butchered that. It's dated 7/20 of 20. Page 3 is the officer's narrative, and the officer met with the victim at the scene, and the victim informed officer that she parked her van on the street, grabbed the packages for the residents, proceeded up the driveway. She made it approximately 3/4 up the driveway when she noticed the dogs coming at her. She advised that 2 Great Danes bit and clawed at her. And then it says Officer Kerr spoke with the owner of the dogs, Ms. Sokol. She explained the dogs were out and an invisible fence surrounded the property. She did not witness the incident. Officer Abel noted 2 warning signs in the driveway, pulling up to the residents, one advising beware of dogs. The second document I would direct you to is a supplemental report. This one by Detective Miles Schrage, S-C-H-R-A-G-E, was generated on 7/31 of 2020, so 9 days after this incident. This report was also recorded, and I think there's some pertinent provisions in this report that demonstrate conclusively that the victim was trespassing. The third paragraph of that report states, the victim stated on July 20th of 2020, she was delivering packages for Amazon. She parked on the side of Northwest Beaver Drive across the street from the 7040 Northwest Beaver Drive address. She advised it is against their policy to park in the customer's driveways. Now, we have a couple contentions with that. One, as I said, we would be happy to submit an affidavit or evidence from Amazon personnel as to what their actual policy is. We'll also note for the record, and this is confirmed in the audio recording, that the victim testified that this was, not testified, but stated to the officer that this was her, quote, second day on the job. So she states that she retrieved the package for that address and began walking up the driveway. She advised that she saw, quote, no trespassing, end quote, signs as she walked up the driveway, but said she was delivering their package, so she continued up the driveway. There's several pictures of the no trespassing signs in the various officers' body camera videos that are clearly visible. The officer again stated that he noticed them on the day of the incident. As the council will be able to see, there's no exception for if you're delivering packages, you can trespass or you're welcome on the premises. She says she continued up the driveway, kept walking up the driveway and saw 2 dogs. Notably, she doesn't say she turned around or did anything when she saw those dogs. In some of the medical records, I assume someone's gone through them, there's various statements as these dogs just attacked me. Well, 9 days later, she verifies this was not accurate. She said one dog approached her and jumped up on her right side. She thought at first the dog was just trying to say hi and be friendly with her. That is when the victim said both dogs went after her and began attacking her. And she wasn't able to provide some specifics. Later on, she mentions she thought both dogs were black. That's obviously not the case. Again, it's our position that under the code section, there is no way that these dogs can be declared a dangerous or potentially dangerous animal, or dog, excuse me, because they meet at least two of those subsections in 5511 subsection 4, namely being subsection 4.4 and subsection 4.6, defending the property against trespass and because this victim was injured when she was trespassing. Other than that, I don't have anything else to add at this time. Thank you very much.
Thank you. Mr. Hanley?
Honorable Mayor, council members, I'm here representing the Johnston Police Department in regard to this matter. I respectfully disagree with Mr. Kresowick's statements relative to the statute and relative to the definition of trespass. It was offered by Mr. Mallory at the previous hearing in regard to the 1979 Attorney General decision that's been part of the record. In that decision, it is clearly expressed and defined that there is the allowance for entry on the property of an individual if in fact there's implied consent and approval to do so. The circumstances of this case are items that were ordered by the owner of the property from Amazon for delivery on the date in question. The fact that the owner knew that there were items that were ordered that she voluntarily and knowingly ordered to be delivered, the responsibility is then hers in order to make the conditions safe, but certainly by doing so created the implied consent for that delivery to be completed. We cannot now look to the dogs to say that they were trying to protect her property. They don't understand that distinction. She understood and needs to understand that distinction, that in fact she gave that consent when she placed the order, and the expectation was that order was going to be delivered in its normal course of business to her residence. Therefore, outside of the provisions as provided by counsel in regard to trespass, there was no such trespass because implied consent to enter the property overrides the posting of the signage and is not to be interpreted any differently by someone who approaches when they've in fact doing their job to deliver the packages that were ordered by the owner of that property. The warning signs become insignificant and irrelevant in that respect. It was the duty of the owner to protect those invitees, which this driver would have been. You're invited to my property to make delivery. It is now the owner's responsibility to provide property that in fact is safe and is free from injury to people who have been invited to that property, which this driver was. That opinion on implied consent is clear, and that's exactly what in fact occurred here. So the idea of the fact that 5511.4 somehow is outside the purview of this matter because of the fact that there was a trespass, that simply does not meet the law and does not meet the Attorney General's opinion as cited previously. I don't have anything further at this point in time based upon what has been offered by argument by counsel. Other than that, the record speaks for itself.
Thank you, Mr. Hanley. Mr. Kresowick, do you have a rebuttal to what Mr. Hanley has just stated?
Yes, briefly. Thank you, Madam Mayor. In the Attorney General provision, the summation at the top of the first page explicitly states no trespassing signs are sufficient under 716.72B when the alleged trespasser is actually aware of the signs. Here we have confirmation from the victim that she saw the signs, and there were multiple signs, including one that explicitly references dogs. Second, to the point that my client ordered the package, I'd have a couple comments. One, it's my understanding, and once again, we'll ask permission from the council to submit further affidavit or evidence on this, that the package wasn't supposed to be delivered till the next day. Second, regardless of when the package was supposed to be delivered, our client is entitled to rely on Amazon's own policies for their carriers and people who are delivering their packages. Again, we'd like to submit evidence as to what Amazon's own policies are. If this victim was violating Amazon's own policies by her actions, including after seeing the trespassing signs, proceeding down the driveway, then clearly we should be able to rely on that, and there is no implied consent. At a minimum, I think it was certainly unreasonable for her to continue approaching the residence, and there's a drawing that I believe she submitted on the 30th, as part of that report, where you can see exactly how far she goes towards the residence. And I'm not sure if this is already in the record or not from the prior hearing, but the underground fence, which contains the animals, doesn't go even halfway down that driveway. And our client had a procedure where every other delivery person for the last half a decade had followed, and clearly there were no incidents. So I think at a minimum, again, we respectfully request the opportunity to submit evidence with respect to the Amazon policies and procedures, and then additionally from our client with respect to when that package was supposed to be delivered, her procedures with respect to delivery of that package, and then how far out that underground fence goes. Thank you.
Madam Mayor, I only want to speak to the fact that if we're going to allow additional documentation or evidence to be entered, clearly the department has to have the opportunity to respond and verify the authenticity of that information.
Yes.
For the record, we have no problem with that.
Anything else, Mr. Hanley, in response to what Mr. Chriswick has said?
No, Your Honor, Your Honor, Madam Mayor. In regard to the response, I have nothing in addition other than, as previously stated, the record is clear, and the circumstances of her doing her job, she was doing that, and I think the evidence will clearly demonstrate that the delivery, in fact, was to occur on the 20th, and everyone knew that. The idea that it was supposed to happen the other day is unsupported by the evidence.
Does the council have any questions for either of the attorneys, Mr. Chriswick or Mr. Hanley? Hearing none, then Mr. Chriswick, do you want to make your motion?
Yes, thank you, Madam Mayor. Council members, we respectfully move to have the opportunity to submit affidavits or other evidence in response to the documentation that was provided to us by Dropbox on the 10th, including but not limited to affidavit from our clients and an affidavit plus evidence of Amazon's policies for their own, I assume it's employees and subcontractors, however they structure that, with respect to dogs and delivery to properties of the nature of ours. Thank you.
Mr. Chriswick, is there a reason why you got our attention on the affidavit from the client? Is there a reason why the client could not have participated this evening?
I don't know, Your Honor. Your Honor. Madam Mayor, I'm sorry.
That's all right.
I think one of the reasons was we weren't, I didn't think this was an evidentiary hearing. It
It's not an evidentiary hearing. That's my concern by what's being requested, Madam Mayor. The fact of what's being offered in what has been stated in this motion, other than being able to address the documents that are claimed to not being available on the Dropbox, everything that's been stated in terms of the Amazon people and or affidavits from the owner or any other party are all items that would have been evidence available at the initial hearing. Only in the circumstances that this council finds that those items are deemed necessary for them to know for purposes of making their decision. But in terms of the fact that it is additional evidence that was in fact available, it should not be allowed to be added to this record.
May I respond briefly, Madam Mayor?
Yes.
Thank you. I think the same could be said then for half the documents or more of the documents that were submitted on the 10th. I mean, I don't see how those were not available either at the initial hearing. Thank you.
So going back to your request, Mr. Creswick, you're proposing to submit an affidavit from Amazon regarding their policies and procedures. You're also proposing an affidavit from your client regarding, I guess, her procedures. And then what was the third one?
Well, in combination with the Amazon affidavit, I believe there is written documentation of what their policies are, so we would attach that to the affidavit, I assume verifying that these are their policies or procedures. And then it's hard to say without being able to see some of this, and I know you've already covered that, and I apologize if that was on our firm for not being able to see those, but I can tell you, I can't see some of the other documents that were provided on the 10th. Just being able to respond to those by the same token that Counselor wanted the ability to respond to our documentation or verify the authenticity, we respectfully request the same sort of courtesy with responding to the documentation submitted on the 10th.
Well, Mr. Creswick, Mr. Mallory did receive those other documents on the 10th, which was several days ago now, so he did have an opportunity, and he could have informed us that he could not see them if that in fact was the case. But you know, I don't have any reason to believe that they're not there on his end, because they're there here on our end, and it's the same Dropbox. So I wonder. I don't understand why he makes the claim that he can't see them. It seems
May I
to
ask
me,
a question?
I'm sorry?
Mayor, may I ask a question?
Let me make my statement, and then I'll let you ask a question, Council
Okay.
Evans. It seems to me that any statement that the client would be making now, she could have made at any time previously at either one of the prior hearings or even before today. So, you know, I will let the council decide, make a decision on this motion, but it seems to me that that should not be allowed. In terms of the procedures of Amazon, you know, I think the procedures themselves the procedures should speak for themselves. If you want to submit that, certainly, you know, I don't see any problem with doing that. I don't know if the affidavit only just says this is what the procedures are, then, you know, I guess there wouldn't be any dispute there. But if the affidavit goes beyond that, I would have some concerns, and I would share the same concerns that Mr. Handley has. But Councilman Evans, you had a question?
Yeah, since this is an appeal based on the decision that's already been made, shouldn't we be only looking at the evidence that's already been presented to the city manager so that we're all reviewing the same information so that we know what he had based on his decision is what we're looking at to make sure that, because it's an appeal. It's,
Right.
I don't understand new information coming in at this point.
Councilman Evans, let me respond to that. Under our code section, 55.10 subsection 7, it does say the hearing shall include a record made before the city administrator, the arguments of the parties or their representatives, any additional evidence which was not available at the time of the appeal hearing before the city administrator, and any other information the council deems necessary. So I believe that the city, under their notice of additional necessary evidence, information it was a combination of information that was not available at the time of the hearing and information that we would want the council to deem as necessary, or if the council deems as necessary to review to make their decision.
Okay, thanks for clearing that up.
This is Councilman Cope. I guess based on kind of what Tim just said, I think that we probably should handle both any statement from the property owner, the owner of the dogs, as well as the Amazon procedures in the same way, because they both appear to me to be new information that as Tim talked about it. So while it's sort of different from a typical appellate process that we might expect, it's sort of consistent with what our ordinance says. So I'm fine with keeping the record open and allowing the counsel for Ms. Sokol, Dr. Sokol, to submit these documents. I don't know that I'm going to be particularly sympathetic to them, but still willing to see what he has. And so I think based on kind of what our ordinance says, I think we should allow the record to remain open and to receive these documents. And then when we meet next, we can then make it based on what we've heard tonight and then what additional information we have, then we can make a decision.
Mayor, I would like to also ask a question. When I agree with what Councilman Cope has said about getting all the information, but I would also like the additional information of the ramifications of declaring these dogs dangerous. I read through a little bit of the ordinance. It seems to me if they're declared dangerous, do they get returned to the owner? Is there additional requirements imposed upon the dog by being declared dangerous? If they're not declared dangerous, then they just go back to the homeowner and the sign that says beware of dogs is all that is needed. I guess I would like someone to explain to me the ramifications of what we're deciding.
And Councilwoman Martin, that is all laid out in our ordinances. But maybe if the chief or if Mr. Hanley could just respond to that very briefly.
Under 5513 and the subparts of your ordinance, it does set forth a detailed explanation of what is to occur upon the declaration and then the ultimate finding of a dangerous dog, that there is a, again, defined procedure for how those animals shall be treated to protect the public safety and how they're to be returned, if ever, to the owners. But it's spelled out very clearly as to the defined procedure that the council is to follow once there's a declaration.
So I read through that ordinance and I guess I saw that the dogs could be confined to the yard with an electronic fence, and as long as there was a dangerous dog sign up. And it was unclear to me whether or not they would also, in addition, have to be leashed when they are outside of the yard. And maybe that's because I didn't read it through enough times. But they do. This current homeowner does have an electronic fence. She does have signage. So I'm looking for the details of what in addition needs to be done.
I will have the chief speak to that.
Thank you. This is Chief McDaniel. Councilmember Martin, you're getting the provisions of potentially dangerous in 55.12 a little bit mixed up with the provisions of dangerous in 55.13. So with the provisions in 55.13, that's an escalation. It's a higher level. So where you see the fencing and some of those more entry-level requirements, that's in the potentially dangerous. So with this, what we're saying is that the animals have to be confined to a structure, that if they're outside of that structure, they have to be attended to, they have to have a muzzle on them, they have to be leashed. There's a requirement for an insurance policy for liability purposes. There's a lot of depth in the type of pen or kennel or structure that must be in place once you're declared a dangerous dog. You also have to look at the home as far as the provisions of can the dog easily walk through a door that would lead out into an open area versus not being able to do that. So the structuring aspect is a big component to this. There's also requirements that we make notifications to the neighbors in the immediate area with the dangerous dog. And then we also keep an in-house record of these photos of the animals. There's a requirement for the owner to make immediate notification to the city if the animal would be found to be at large. There's a lot of different elements to that, but you've got some depth of detail there in 55.13. If the ultimate question is if you're declared dangerous, if the dog is declared dangerous, does that require euthanasia? The answer is no, it doesn't automatically require euthanasia. There's provisions within the chapters of the code that provide you to maintain the animal, but also maintain the public safety of the community. If those provisions aren't met, then that allows the police department to go in and seize the animal and escalate to additional provisions that may ultimately cause the removal of the animal from the city or humane euthanasia.
Okay, so the 55.1 provisions are the potential dangerous dog, and so that's kind of an intermediate while the process is happening. Is that correct?
No. It's very confusing, but if you go to the definition section in 55.01, you're going to see a definition for potentially dangerous dog. You're also going to see a separate definition for dangerous dog. And then the corresponding provisions for what is defined as a potentially dangerous dog, that is the regulations at 55.12. If you look at the definition for dangerous dog that is in 55.01, the corresponding regulations to maintain that animal in the city is 55.13.
Okay, so is these two dogs that we're now talking about, Tess and Mandy, are they already judged potentially dangerous?
No, because of the definition of the seriousness of the injuries involved in this case, it went straight to the dangerous declaration. It meets the definition of what a dangerous animal is due to the severity of injury. So if this was a situation where there was a bite that occurred, but it was a minor injury, something to that effect, then we would be exploring potentially dangerous. But due to the severity of the injury that occurred, that's where it immediately escalates to the dangerous. There was another incident that happened prior to this one that I also considered that was about 6 weeks prior, that involved another bite with an individual that had run away from the youth homes facility. So in that case, I took that into consideration as to the disposition of the animals, but we did not make a potentially dangerous declaration or a dangerous declaration in that first case.
Thank you for clearing that up for me. Thank you.
Yes, ma'am.
Any other questions or comments from council members? If not, we would need a motion from the council, if it is the will of the council, to receive the additional information from the attorney for Dr. Sokol in this matter, deeming the additional information necessary. And in that motion, I think that we need to be clear about what that additional information would be. Would it be both items he has requested here, the affidavit and the written policies of Amazon, as well as an affidavit from Dr. Sokol regarding what her policy is with respect to deliveries? Yeah, and what we would need in addition to deeming the information necessary, also that we would leave the record open to receive that information. And then I'll talk about the time limits after we have the motion.
Mayor, this is Councilman Coe, can I ask a quick question?
Sure.
By keeping the record open, does that then allow for the prosecuting attorney to then potentially respond if they decide to respond to the documents that have been submitted?
Well, what I was going to suggest here, or what I was going to direct, is that if the record does remain open and additional information is received, specifically as the motion provides, then we would require that additional information be submitted by 5 o'clock on September 17th, and that Mr. Hanley would have an opportunity for rebuttal by 5 o'clock on the 18th, which would then allow us to make a decision at our council work session on Monday, the 21st at 6 o'clock.
Mayor, I would like to add to that motion the suggestion that, or whatever, however you want to say it, that the dogs, as I understand it, the dogs are not here in Johnston currently. They are still at the animal shelter, or some is correct. And if that is correct, it's not correct.
I can add to that. This is Tim Pearson. I believe today Dr. Sokol went and picked up the dogs, paid the fee, or paid a fee, and that she brought them back to her residence. Pursuant to our code section, she has certain requirements, and I can ask the chief if he wants to comment on that, but she has certain requirements until the decision is made regarding those dogs and the protection of the public in general. Chief, you want to add to that?
Certainly. Pursuant to the initial hearing with City Administrator Sanders, Mr. Mallory made the assurances that the property owner, Dr. Sokol, was able to abide by the restrictions set forth in 55.13 as we continued to work through the appeal process. So with that, he was given notice with the findings of Mr. Sanders as to the ability to retrieve the animals. Sounds like as of earlier today that was done. So from the police department standpoint, the expectation is that as those animals are returned to the city, that 55.13 be complied with, to include the muzzling and the leashing if they're going to be out of doors, that they can't roam freely. We still need the insurance provision met within the code. We'll also be making notifications to the immediate surrounding neighbors tomorrow pursuant to the code. Then there may be additional items that we have to follow through on as well. We've still never gotten clear understanding of the structure and how that's been accommodated to meet the code. We're not sure if we're going to receive that information or not, but it'll be our officers' responsibilities that are patrolling the area to be observing whether or not those animals are roaming freely, and if so, then according to the code, we seize the animals, and it's considered a violation of 55.13, and then we move into the next section of the ordinance.
Chief,
Thank you.
Chief, this is Councilman Cope. Just a real quick question on the ordinance and how it works. So basically the dogs could have been picked up by the owner after Jim Sanders made his decision? Is that what you're saying? As long as they abided by the requirements that you just outlined?
So the requirements of the code are that you have to meet the provisions of 55.13 when the declaration for dangerous has been offered. So pursuant to the quarantine period, part of the quarantine period is a 10-day isolation period. And due to the nature of having 2 animals involved in an attack and some other complicating factors, as well as concern for the safety of the community, they were held in isolation through the quarantine process with the Animal Rescue League. Then through the appeals process, we have provisions within the code that would allow us to maintain those animals at the ARL throughout this appeal process as it continues to move forward. However, we're showing good faith to Mr. Mallory's belief that his client can go ahead and provide for the compliance with 55.13. So we're able to house them or keep them at ARL if we need to, but we're attempting to show good faith in this now that the quarantine period's closed, and we're able to hopefully get this moving forward.
But basically, once the quarantine period expired, then the owner could have come and picked up the dogs. Is that what you're saying?
In this instance, that was, once the appeal was done with Mr. Sanders, that was the point in which they were given notice that they could come retrieve the animals from the Animal Rescue League.
Councilman Cope, this is Tim Pearson. I might want to add that the day after Jim Sanders issued his ruling, that I did send correspondence to Mr. Mallory advising him that his client needed to contact the Animal Rescue League regarding the release of the animals. I also informed him that under what was expected if the animals were released, what was expected because he had already filed an appeal to the council, what was expected pending the appeal to the council in terms of housing the animals at the home under our code section. So Mr. Mallory was informed of that the day after Mr. Sanders' decision.
And that basically, that's been effectively almost 3 weeks because the decision was dated August 25th, 2020.
Right, August 26th was the date of my correspondence.
Okay, thank you.
Other questions or comments?
So the motion is just to include the documents or whatever that he has mentioned tonight.
Here's
Something
what
else
I
pops up tomorrow.
Yeah. Here's what I understand, at least the discussion that we've had so far, what the motion would be. It would be to keep the record open, to allow Attorney Mallory or Kresowick to submit on behalf of Dr. Sokol an affidavit from Dr. Sokol regarding her procedures in receiving deliveries, as well as an affidavit and the written policies from Amazon regarding what their procedures are, and that part of that motion also needs to indicate that this additional information is deemed necessary pursuant to the Johnston Code of Ordinances, Section 55.10.7. And so, yes, that motion would specify exactly what information you have deemed necessary, and that's what Attorney Kresowick or Mallory would be submitting on behalf of their clients.
Madam Mayor, in regard to the earlier part of your introduction of this case, there was the identification of the additional necessary information as submitted by the city and by the police department. I just don't want to lose sight of the fact that that's part of the information in addition to that requested by counsel for the owner.
That's correct, and there was a motion that accepted that as additional information deemed necessary by the council.
Thank you.
You bet.
Mayor, this is Councilman Cope again. One of the questions I have a little bit is it sounds as if that the attorney for Dr. Sokol is indicating that Dr. Sokol has some sort of process to which deliveries, Amazon deliveries, are to be like a drop box or some sort of box that's probably presumably outside the electric fenced area where those deliveries are to be made. If that is what he's saying, and I don't know if maybe can he confirm that that's what he's saying?
Yes, thank you. And it's my understanding, and you can see it in some of the videos, there's a trailer or an area, as Councilman Cope said, outside the electric fence area. And I would anticipate having her, as part of her affidavit, outline her procedure to include, this is where people generally go. And I'm sure she'll attest to the fact that most of the delivery people call in advance, or whatever her procedure is with respect to that. But yes, to confirm, I anticipate.
I guess here's what my expectation is that if as part of your material, that you be able to demonstrate as well whether Amazon in fact has on record that it is able to notify its delivery drivers of unique circumstances of making deliveries to this property. And so, so just some sort of generic, this is Amazon's policy, I'm not, I'm not trying to direct what the evidence needs to say, but to me, you need to produce some sort of evidence, not just that she has that she has a drop site, B, it's clearly marked, and C, Amazon has a record that is that it's delivery policy for this property. So that's the type of evidence I would be looking for in this case, for this evidence to have much impact on my decision making.
And I appreciate you informing us of that. With respect to B, that's going to be difficult. And with respect to C, I don't believe Amazon does have some record. We can try and confirm, but it's my understanding there is none.
This is Mr. Hanley. I would state that the department's investigation and statements that are included in the additional information previously talked about, that in fact the investigation showed from the Amazon representatives, none of that is true and correct. There's been no contact, no information provided, no specific instructions given to Amazon or any of its delivery drivers that would have altered the implied consent to do a normal delivery at the house.
So back to the question. Do we have a motion to keep the record open to allow the submission of this additional information, the affidavit from Dr. Sokol, as well as the affidavit from Amazon, and the written policy or procedure, and the statement from the council or the motion from the council that the additional information is deemed necessary pursuant to section 55.10.7?
I'll make the motion. This is Jim.
This is Councilman Cope. I will second it, but I also, did you include in your description of the motion, Mayor, the timetables that you had mentioned, the 5 p.m. September 17th and September 18th? I just want to make sure that's part of the
Yeah,
motion.
I will make sure that it's part of the record. I don't know that it's part of the motion that the council would be voting on, unless, I guess we could certainly make it part of the motion.
Well, just as long as everybody clearly understands it, then that's that both councils understand that that's the expectation.
Sure. Well, the expectation is that the additional information would be submitted by 5 o'clock on September 17th to our attorney, Tim Pearson. It's a long day. And that Mr. Hanley would have an opportunity for rebuttal by 5 o'clock on September 18th. And that it is our intention to make a decision on this matter at our work session on Monday, September 21st, which will begin at 6 o'clock.
I second that motion.
Okay. We have a motion and a second. Any further discussion? Cindy, vote please.
Councilmember Martin,
Yes.
Ready,
Yes.
Soroka,
Yes.
Coe,
Yes.
Evans.
Yes.
Motion passed. So with that, I think we have completed our work for this evening, haven't we?
So, does anybody else have anything further to say?
Does council have anything further to say this evening? Okay, well then we stand adjourned. Thanks, everyone.
Thank you all.
You.